Good afternoon. I'm Nelsinia Ramos from Wisconsin Facets. I work as the Parent Center Coordinator, but also I do outreach or work as an outreach, multicultural outreach coordinator for Wisconsin Special Education Mediation System. We have the co-presenter today will be Nissan Berlet. He is the Director of Special Education for CISA 7. And today we would like to welcome you to our presentation on dispute resolution options. These options are available for parents in school districts in Wisconsin. We know that issues of conflicts and disputes sometimes arise related to the planning or the implementation of IEPs for children with disabilities. So the Special Education Mediation System has been helping the parents of children with disabilities to solve these disputes since 1996. The presentation will provide you with information about the WSEMS system and the free options for early dispute resolution that are available through our ARCH system. But also we will provide information about how to access these options and also the information about the results of the system over the past 20 years.
So, thank you, Nelsinia. So as we move on to the next slide, the Wisconsin Special Ed Mediation System, or WSEMS, we'll call it for short, was funded by Wisconsin DPI with an IDA discretionary grant to CISA 7 since 1996. For all these years, the goals of the grant have been, number one, to administer the system, to provide mediators to parents in school who need it throughout Wisconsin. To provide a roster of mediators to assist with the resolution, and as well as to provide training and outreach about the system, just like we're doing today, as well as to collect longitudinal data for ongoing evaluation of the system that, as Nelsinia mentioned earlier, we'll be sharing with you throughout the presentation. Our system, WSEMS, is unique. It was nationally recognized by CADRE, which is the Center for Appropriate Dispute Resolution in Special Education, as one of the 4 states that were considered that have exemplary system because primarily our involvement of our stakeholders and the outcome of our dispute resolution, mediation, and IEP facilitation. Our system was designed by a 17-member group of key stakeholders in 1996. Half of them represented parents groups and half represented school groups. The WSEMS Stakeholder Council still exists today and continue to serve as a collective advisory body for the system. Our system is also unique nationally because it is led by a team, 3 people, that model partnership and provide oversight to the system that includes a special ed director, that's myself. As Nelsinia mentioned, I am special ed director for CISA 7, that includes 38 school districts, and my role on the partnership is to provide the school perspective. Jen Sirac, one of the founder of WSEMS, and is currently the Wisconsin Facet CEO. She is a parent of a young adult son with autism, and she represents the parent perspective on the team. So you have the school perspective that I represent and Jen's perspective of the parent. So we have those 2 parties' perspective represented on our system. Nina Meyerding, she represents the perspective of a dispute resolution professional. Nina is an internationally known mediator, lawyer, university professor who conducted over 4,000 mediation and has trained thousands of people in dispute resolution skills in almost 50 states as well as internationally. The staff for our system include Jane Burns from Burns Mediation Services. She's a WSEMS intake coordinator and administrator. So when you call that 800 number that we will share with you shortly, she's the person who you will speak about your issues. She explained what is involved with mediation, facilitation, She assigned the cases to the mediator and facilitator. She has worked with our system since 1997 and has handled over 1,300 requests for mediation and IP facilitation. Nausinia Ramos, a parent and a member of the Wisconsin Facet administrative team, is the multicultural outreach coordinator, and Nausinia is the co-presenter today. Other areas in which WSEMS was recognized by CADRE was our historically high rate of signed mediation agreement, being one of the first states to provide IP facilitation and neutral facilitation for resolution meeting, establishing continuous quality improvement practices, including participant surveys, ongoing training for the roster, and feedback from our stakeholders. So as we move to the next slide, you have a diagram that it's a visual of all the options that are available in Wisconsin to resolve disputes related to special education. You also have a copy of that in your handout. With all four options listed on the light green arrows, parents and school will have control over the outcome as they are working together to solve the issue. This is called self-determination. The darker slide show processes where someone else has control to and make the decision. The first one that we have, the informal meeting, which is the first arrow to the left, is not a process provided to WSEMS. It is simply a meeting between parents, classroom teacher, principal, or special ed director. While it can be used at any time, it is especially effective if used earlier in the relationship between the parent and the school. The other three light green arrows are all available through our WSEMS system: mediation, IP facilitation, and resolution process. In all three, one of our mediators or facilitator can help the parents and school work together to reach an agreement to meet the education needs of the student. In addition, all three WSEMS options start with a case intake by Jane Burns that I mentioned earlier. All of them are voluntary, and all of them are free to parents and schools in Wisconsin. As you move from left to right on this diagram, the dark green arrows indicate processes that are available in Wisconsin, but not through WSEMS. That's where the control of both the process and the outcome shifts away from the participant to someone else. For example, an IDA complaint will be decided by DPI staff, due process by an administrative law judge, and litigation by a judge or jury. So now, Senia, you're on the next slide.
Yes, Nissan has mentioned about the intake process for the mediation system. We're going to be referring our mediation system as WSEMS short. So in this diagram, we have the explanation on how we take the cases. So it shows the case intake coordination process, but in the red, starting on the red box, when a request is received for any of the three options available through WSEMS, Nissan just mentioned those, the mediation, facilitation of IEPs, and the resolution meeting. This goes directly to Jane Burns, which is the administrator of WSEMS, and she has no affiliation with any parent or school groups. It's important for us to mention that because she's not a parent of a child with a disability and has never been working with any school. So she provides an impartial beginning to help parents and schools determine which of the three processes may work the best for them. Following the purple box, Jane conducts and through the case intake process, she includes the screening where Jane gathers information about the situation, including the child's name, the age, the school, the grade, disability, the contact information for the school, etc. So she also spends time answering the questions and educating the parties about the different processes available through WSEMS and about the neutrals on the roster. The neutrals are the mediators and the facilitators. I want to mention that you will hear us to say the word parties often during the presentation in our system, because parties for us will generally mean the parents and the school staff. So once with impartial intake, Jane technically do the analysis and uses all the information she gathers to help determine the case, and to be sure that it meets the criteria in order to use the system or to take the case. The blue box is the process of educating the parties and answering their questions. Jane helps them to better prepare to make their own decisions about what to do next. Following them, the green box, when parties have enough information from Jane or the school district and the parents have enough information, they are usually able to make their own decision as to whether to use the system, and they can also decide which process they would like to use. The orange boxes are all of the options available through WSEMS. So we want to point out that while not part of the WSEMS, Jane Burns also serves as the neutral intake point for birth to 3 mediation cases. And those cases are administered by the Department of, or birth to 3 is administered by the Wisconsin Department of Health Services. So right now in our conversation, or for the purpose of this presentation, we'll be focused on the cases of children with disabilities that have IDEA or IEPs from the age of 3 to 21. In the 17 years from 1998 through June 2015, the system have had 1,355 requests for mediation. 949 of those requests went actually to mediation. That means it's about 70% of the conversation rate, but also 87 of those resulted in a written agreement. So that is a really high. I mean, we're talking about 87% that actually, are becoming to have an agreement between the schools and the parents. In the 11 years, because in 1998 we only have mediation, but we included in 2004 the facilitation of IEPs. So from 2004, when that started, to last year, 2015, we have had 386 requests for IEP facilitation, which 257 of those actually were held, and 92 of those, which is 236 IEP facilitation cases, resulted in developed or revision of IEPs. So now I'm going to explain a little bit about, or talk a little bit about who are or what is the WSEMS roster. Who are our mediators and the facilitators? Some states have just few mediators and facilitators, other states may have many. Some states use mediation centers, and some use administrative law judges, and some use their state employees. In Wisconsin, our roster has around 20 neutrals who are contracted through our system and are not employees. Our neutrals are used for mediation, IP facilitation, and resolution meetings. A key component to successful dispute resolution system is the impartiality of this roster. Not only are WSEMS neutrals not employed by the SCA or LEA, which means the school education agency or DPI or the local school agency representative, but if any member of the roster becomes employed by or serves on the board of a parent organization or has a contract with the school, they are declared as inactive member of the roster. WSEMS has an application and interview process to select members for a roster. The WSEMS partners and staff decides on who the mediators and the facilitators will be. Potential members of the roster attend a 5-day training conducted by experienced special education mediators and WSEMS stakeholders. The participants then are observed by the partners and staff. Just because someone has taken the training does not guarantee that they will be on the roster. Our intent is to have available a roster of diverse, impartial mediators that will be acceptable to both parents and schools. As a result, WSEMS neutrals have very broad range of professional backgrounds and varied experiences mediated in different areas. Besides special education, we have neutrals experience on labor, farm, medical, workplace, elderly mediation, etc. Once selected, an annual one-day annual training is required in order to stay as an active member of the roster. We use stakeholders for this training also. A parent and school attorney always present legal updates together, and optional additional trainings are provided to the roster on diverse issues, including cross-cultural communications and working with high emotion, and also how to make conflict constructive rather than destructive. Either party, the schools or the parents, can suggest a specific mediator or facilitator for the process. They can write their name on the request form, or they can just tell Jane Burns which one they would like. If the parents do not have a specific request of the parties cannot attend to the same person, Jane Burns will work with the parties to find a mediator or facilitator who will be well matched to their case.
Okay, so thank you, Narcinia. So now we're going to look at take a closer look at each of the options. The first one we're going to be addressing is the WSEMS IP facilitation option. So as you saw from the previous diagram with the arrows, it's one of the earliest options to resolve dispute that's available to WSEMS. In that, we have a trained impartial professional from WSEMS, one of our mediator or facilitators, which, by the way, it's each of the neutral that we have on our roster can function as either a mediator or facilitator. They all have the training to do that. So one of those neutral attend the IP meeting to help the IP team by facilitating the IP process. As we'll see later on, it could be done for any IP meeting, initial, re-eval, or annual IP. And as Narcinia mentioned before, it is an option that's free for all participants. So as we turn to the next slide, how can you tell if mediation or IP facilitation might be, or which of the two is the more appropriate option for you? So IP facilitation is good to use when parents of the school think that an IP meeting is going to be very difficult to manage, very difficult to hold. That is when there seems to be a lack of trust, when either party lacks the trust in the other, or when there are some problem with communication. Another time that we recommend, that we think it's most appropriate to use IP facilitation, is before an impasse, before the parties reach a brick wall in terms of how to take the next step. So the WSEMS stakeholder group determined that a facilitated IP could be able to be used for any IP meeting. As some of you know, all of you know, that there is initial IP, then there is an annual IP. It has to be done, obviously, annually. And there is a IP that requires a reevaluation every 3 years. And then there are some intermittent IP, such as review revision, that occur throughout the school year. That WSEMS option applies to all of those that we mentioned. So as we move on to the next slide, so if you think that a facilitated IP is the right option, that a parent or school can make the request for IP facilitation either jointly or individually. Those who wish to do that can access WSEMS through the phone number that you see on your slide, or you can write to WSEMS PO Box 107, or actually the address that we have on the information. When a request is made, Jane Burns will talk about how facilitators can be helpful. Jane will be available as a resource throughout the process and will help each stage of the way. If one party requests facilitation, then Jane Burns will have to contact the other party and make sure that they are willing to participate, because as we mentioned earlier, it's a voluntary process. If one party says no, then an IEP will be held, but without a facilitator. So it's best if a request for IP facilitation comes from both parties. Parents, school can talk together and jointly request IP facilitation. Then it will be the most speedy process. IP facilitation meeting is held at a time and place that's acceptable to all IP team members and the facilitator. If a date has already been set for an IP meeting, Jane Burns will find a facilitator who is available on the date that the parties agreed to work with. If the date has not been set, then the selected facilitator will work with the parents and school to find an acceptable date and time. In either case, the school district is responsible to send out the IEP facilitation, the IEP invitation, I should say, to the parties. So as we move on to the next slide, where we talk about the participants. So participants of an IP facilitation are the IP team members who are required to attend the IP meeting, as well as the facilitator. But as we will describe in a few minutes, the facilitator is not a formal member of the IEP team. And we'll see this in the next couple of slides. So as we move on to the next slide, what is the role of the IEP facilitator? The facilitator role is to help keep the parties focused on the needs of the child and develop an IEP by assisting with problem solving and discussion of mutual goals. The facilitator can clarify points of agreement and disagreement, and perhaps most important, reframe points of disagreement into manageable discussion. This is how then the discussion is focused on solving problem, not at stating claims that will not take us to a more constructive end. The facilitator can help the IEP team discuss specific steps of what will occur after the IEP meeting, who does what, when, and where, and suggest ways to address future conflict. But I think it's important to recognize that the IEP facilitator makes no decision for the IEP team. In other words, they don't deal with the content, they deal with the process. What is meant by that is he or she do not get involved in the discussion, should the student have a teacher aide, if this is the topic of the IEP facilitation, or should the student spend more time or less time in a regular education classroom, again, if this is the topic of the IEP facilitation. Their role is simply to make sure that the way the parties communicate with each other becomes constructive for developing an effective IEP document. So as we move on now to the next slide, which talks a little bit about some of our data. We mentioned earlier that we provide survey to all participants, and this is our way to ensure quality control of our system. So all the participants and the facilitator are asked to complete a survey about the session. Information is given anonymously and remains confidential. Survey helps us to measure how our system is working. The only thing that is shared publicly is data, just like the one that you see on the slide, that is aggregate and does not include any identifiable information. And that's what we tell our parties, and we protect that throughout the past 20-some years, because we found out that if information about individual districts or parents become public, it tends to send a chill into the system and people don't use it. That's what we have seen happen in other states. So when we designed our system in 1996, we made sure that confidential information stays confidential, and information that becomes public does not have any identifiable information. And as you can see from the slide, since 2004, for the 10 years since 2004, but 89% of the folks were satisfied with the process. 77% felt that gave them opportunity to be part of an IEP process. 76% thought the IEP facilitation will improve future IEPs. 86% will use the same facilitator, and about 82% thought the facilitator was impartial. Why is that significant? Is because folks or parents who seek an IEP facilitation is a very selected group of of parents that do not have trust in school. So to see that positive response from that selected group suggests that the system is working well. And now, Senia, I think you have the next slide.
Sure. Thank you, Nissan. So now we're going to be talking or a little bit more explaining what the mediation process is. So in mediation, a trained impartial person, or what we call the mediator from the roster of neutrals, they facilitate the discussion and helps the parties to reach their own agreement, as we mentioned before. But since IDEA in 1997, the mediation is the dispute resolution option required by federal and state laws to be available for free to the schools and the parents. We have provided you with our mediation manual. It's one of the handouts that you have available. And the manual itself includes an overview of the process in the 3 sections. One is for parents, the other section is for the school representatives, and the 3rd section is for the attorneys or the advocates. So the manual is helpful to all individuals considering mediation, as it provides the ideas, the forms, and the techniques useful for preparing in mediation. When people or the school districts or the parents decide to go through the system, it's useful to go over the manual because it provides exercises and ideas about in preparation for mediation meetings. So certainly that's something you have there available, and always remember that if you need a copy, you can give us a call and we can send that to you. But the confidentiality provisions are in both federal and state laws, and they're important to participants because they feel they can share more and discuss different options if the process is confidential. The mediator may not be called to testify in any future civil proceedings. So in addition, unless some other states, WSEMS, through its stakeholder council, decide that even the names of the parents in the school districts will not be shared as part of the data provided to the Department of Public Instruction, or the same for any other agency. In WSEMS, shares with the department all the public, the number of requests, the number who declined to use the service, the number of agreement reached, and all the parties to the mediation sign a confidentiality provision before mediation starts. This means that the discussion in mediation must remain confidential with the limits of the law mentioned above. No records are kept by the mediator, and if a mediator agreement is reached, only the parents and the school will get the copy. Not the mediator, not the Wisconsin Special Education Mediation System or the Wisconsin Department of Public Instruction. Only the school, and the other copy is for the parent. I want to clarify that if you have used the process of IEP facilitation, you can still use mediation too if you think that more work needs to be done to resolve the issue. So both processes can be used, not obviously not at the same time, but one following the other if more follow-up is needed or there's more issues that are not being addressed or need to be addressed or new issues attached to the issue that is being in the process right now. So to all this, when the same for the facilitated IEP, Nissan explained that before, but now it's like when to request mediation. What are the differences between IEP facilitation and mediation? Well, the mediation is best used when help is needed to settle a dispute, a specific dispute, and when communication between the two parties is not or has not been constructive and productive in the past, or when impasse has been reached, is when we hit the brick wall that Nissan mentioned before. And for example, there's a discussion that has no movement forward, or when there is a strong history of dispute between the parents and the school. So it's like a yes or no, or you feel there's hopeless now, is when mediation should be used or could be approached. So a referral for the special education must have been made or to use mediation. And other reasons for mediation could be the possibility for creative, flexible solutions, the forward-looking process or the focus on the future. Also could be considered because the cost of savings is resolved quickly because it avoids time and expense in preparing for facility or participating in due process hearings when many times you have to involve an attorney or you should be involving somebody. But the parties are the decision makers in this process, and the change to preserve the good relationship is one of the reasons. So this is obviously mediation looks forward to solve the situation now and improve the situation in the communication, and this will certainly help for the future. Something that the other processes that are not part of the system fail into do it because it's a yes or no, somebody will decide in what needs to happen. With this, it's creative and it helps to improve the relationship between parents and school districts for the future. But perhaps the most significant actually impact of the mediation could be the establishment of a collaborated partnership that is not only helps in resolving the present dispute, but also provides the parent and school with a framework to resolve the future disputes. Every step of the mediation process is voluntarily, so you only can participate if you want to, and you can stop anytime you want to as well. If a parent requests mediation, the school does not have to agree to have mediation or vice versa. If the school requests the mediation, the parent doesn't have to agree to have the mediation as well, but they both have to have an agreement for the mediation to happen. So no one other than Jane Burns knows which parents or school or even which school districts request mediation. We also have a request form for mediation. It's similar to the facilitated IEP, but this form must be writing and it has to be sent to the WSEMS office. Usually the quickest way to get the mediation is through a joint request. So both parents and the school have to sign the request form, but the process can start with just one signature. A single request takes longer because Jane needs to follow up with the other party to get the second signature. So if you would like to see this form, it's on the mediation manual. You can see it on the appendix. It's Appendix H, and a copy of that form is available the manual, but it's also available on our website. This is a small space. There is a small space in which the person can describe the dispute, and it could be only at that point when you request it, doesn't have to have much of details. It could be something just like transportation issues. Jane will take care of during the screening to get more of the details, and she will not share those, although, I mean, it's confidential information, but it will help to move into the process. It's important to mention that the scheduling mediations, they are always scheduled within 21 days of having this form received. So the mediation works with the parents in the school to schedule the mediation session for a date and location convenient to both. So once Jane gets this form and get the screening, the case will be assigned to a mediator, and then the mediator will get back to the parents in the school districts to schedule the meeting. Regarding the meeting itself or the process or the day of the mediation usually takes part of a day, and some parties may need an additional session if the issues are very complex. So the average, we have been collecting this information, the average time for a mediation is 4.5 hours. When setting up the mediation session, though, the mediator generally asks the parties to agree on how much time they have available to meet. This might be a few hours or a full day, depending on what the parties decide. Once both parties agree to participate in mediation, the next step for them to both agree in which mediator to use. So the mediation participants, the mediator also asks the parties to identify who else they would like to have to participate in the mediation. So in Wisconsin, our law provides the mediation participants automatically may include 2 parents or a competent adult student, and also 2 school representatives. Since the school representatives are not defined further, one of the representatives could be the school attorney. Per our law, other people can participate, but the parties might agree on who those additional people can be. For example, if any other people that parents would like to have to attend, for example, the parents think that could be the relatives, the neighbors, or advocate attorneys, for example, that must be approved by the school. So this is additional of the 2 parents or the student and the parent that will be participating. The same way will be if additional people the school feels will be useful, like other IEP members, that might be approved by the parents. If the parties have been working with attorneys prior to mediation, it is usually better to have them in the room so that they can hear the discussion. Otherwise, the attorney will be consulted after the meeting or during the meeting by phone or email. Since the attorney has not been part of the meeting, it can take more time to discuss what has happened. In addition, the attorneys may be helpful in providing legal advice during the mediation, as mediators are not allowed to give any legal advice. So in terms of what does the mediator do or what is their role, the mediator helps the district and the parents decide how or who will be participating in the mediation session. And the mediator spends time to make sure that the participants understand what to expect from the mediation, but they also help facilitating and structure the discussion between participants during the mediation session. However, their role is not to impose a decision. This is important to us because they cannot give legal advice or interpret law during the mediation session. The goal is to help parties communicate more effectively and to reach an agreement about their issues. So, what do we do in mediation? The process itself is informal. They often, everyone in the room, is the same. Sometimes the mediator meets with the participants separately. That's something that we call caucus. But let's say that during the opening of the mediation, at the start of the mediator goes over the agreement to mediate, and the mediator and the parties may review the confidentiality provisions of mediation. Everyone present signs that agreement. So now the mediation starts. So during the mediation, the mediator explains the mediation process and the mediator's roles. The mediator can ask participants to explain why they're here and what they would like to see as a positive outcome to resolve their dispute. The mediators also ask questions to clarify, brainstorm, or create options during the conversation. There is no audio, video, or written record of this session. That is not allowed. So, finally, in terms of mediation and the mediation agreement, mediation must be written, the agreement. If the parties become to an agreement, which you heard before is 87% of the mediators that the mediations that happen that may have an agreement, the mediation agreement must be written, and there is no specific form for that agreement. The parties write down how much they have resolved the dispute, and the agreement should be very specific in terms of who is going to do what and by when. If there is any pending processes, for example, due process hearing or maybe an IDEA or Office of Civil Rights complaint, perhaps even litigation pending, it is important to indicate if the parties have agreed to withdraw that process. It's important to include a statement that parties agree to go back for mediating if things fall or start falling apart. So in terms of mandatory language, this is a statement that will be always included. All discussions that occur during mediation are confidential and may not be used as evidence of any hearing or civil proceedings. The agreement also should include a plan to share information. The agreement should never be attached on the IP because it's confidential. So the plan should be like how people will know or how this will be followed up. The mediator can write the agreement as directed by the parties, but they should never write the agreement for the parties. Remember that the mediator cannot give legal advice, and there is a concern that the mediator might be practicing law without license if they write the agreement in their own language. So once the agreement is written, just parties they sign it, and either or both parties can, or the attorneys, if in this case they're involved, they can review the agreement. As stated before, I want to make an emphasis on this, only the two parties get a copy of the agreement, not the system, the mediation system, or the Department of Public Instruction. In Wisconsin, the agreement is legally binding, so this means that it's enforceable under the Wisconsin contract law. And WSEMS does not have any responsibility for enforcement of the agreement. People tend to follow the terms of mediated agreement because they participate in developing the terms